Good morning. Thanks everyone for joining. We're going to go over some of the basics of prenuptials, who needs them, why they need them. I will tell you, in the last 10 years, maybe 15 years of my 35-year plus practice, prenups have become extremely common and much, much more popular. And this is the reason we thought this was a topic we should talk about. I've probably done more prenuptials in the last 10 years of my practice than the first 25. So there's a reason, for whatever purpose, societally wise or relationally wise, that these have become popular. So I hope I can answer questions at the end if anyone has any. What is a prenuptial agreement? Pre meaning before, nuptial meaning marriage. So it is an agreement signed before a couple marries. Some folks get this confused with post-nuptial. That obviously is after the marriage occurs, and the rules are very different at that point, because once a marriage occurs, there is a legally recognized marital relationship in the state of New York, which is very different from before. Domestic relations law, section 236B, not that anyone wants to look that up and read it, but in a nutshell, it is an agreement made before the marriage duly executed. That's a key point we're going to talk about. What is duly execution? The agreement may include ownership, division, or distribution of separate property, which is property owned prior to the marriage, as well as marital property, which is property acquired during the marriage. New York State looks at the marriage as a timeline. It has a beginning point and an ending point. If you are going to separate or divorce, beginning point is date of marriage, ending point is when you separate or divorce legally. So the definition of what is owned before the marriage as separate property versus marital property is what this prenuptial can address. It is covered by New York State law, but most, I believe all states, quite frankly, do acknowledge prenuptial agreements. The question is, what state law will apply? Whatever state the parties are entering into the agreement in should be the governing law, because the laws vary from state to state. But the agreement can specifically say that in the event of any dispute in the future, New York law will be the source for interpreting it. So you don't necessarily have to worry that if I sign one in New York, but later we're living in California and the laws are different there, I may have an issue. No, the agreement can say New York law will apply. And of course, in order for the agreement to be enforceable, the parties have to actually marry following the signing of the agreement. Okay, so who needs a prenuptial? Why are these becoming more popular? Second marriages. With a still close to 50% divorce rate, we have a lot more second marriages going on, and people may be gun shy from going through a terrible separation or divorce the first time, and they want to have more control over the outcome. With children in particular, if there are people coming into marriage who have now accumulated a certain amount of assets, business interests, things of that nature, and they have children from the prior marriage, they want to make sure that their assets will be there for their children. Persons with children from prior relationships, maybe they weren't married previously, but they have children from a prior relationship, and they want to protect their estate and their marital assets to some extent for those children. If there's an inheritance coming, someone is expecting to get an inheritance from the family, even though technically under New York State law, inheritance is separate property. Very, very few people know the rules of keeping that asset safely separate so that it cannot be invaded in the event of a divorce. The prenuptial can help define that. Existing family businesses, this is big. We get many folks coming to us for agreements because they own an interest in a family business, or they expect to inherit a family business, and they want to make sure that if their marriage falls apart, the family business won't be invaded. Without protection, one can find that a divorce doesn't just end a marriage, but it also could end a family business, because one of the spouses has an ownership interest, and now the business has to be valued. They have to buy out the spouse's interest in the business, and that could break or bankrupt a family business. Someone comes into a marriage with significant assets, premarital assets that they want to protect. Maybe they've been putting money into pension for 20 years before they marry. Once they marry, the premarital portion would be separate, but maybe they want to keep the entire pension separate, or they just want some very clear definition as to what will be marital versus not marital. Think of a 401k. If you have money in a 401k before you marry, it could be difficult to calculate how much of that is premarital when a divorce happens, because the premarital portion of the 401k is going to go up or down depending on the market forces, and figuring out how to calculate what's premarital versus marital can be difficult. That can all be addressed in a prenuptial agreement. And then if one party is coming into the marriage with significant debts, they certainly, the other party is certainly going to want some protection against those debts. Maybe those debts will get paid down during the marriage with marital assets, or maybe the agreement will be that the party with the debt has to pay down the debt themselves. If the marriage ends, does that debt go with the party who incurred the debt? Some of it may sound pretty basic. Oh, we can agree on that. Once it comes to a separation or divorce, there often is a lot of game playing and one-upmanship, and I'll catch you on this if you catch me on that. Prenups can do away with most of those issues. So what specifically can the prenuptial do, aside from what I've already discussed? It can determine the distribution, not just of premarital assets that may get woven into the marriage, but it can also talk about, if we acquire assets during the marriage, how are we going to divide them? Many people coming into marriages, second marriages, or marriages later in life, want to keep their retirements forever separate. Not just what I had when I got here, but whatever I acquired during the marriage. You're going to keep yours, I'm going to keep mine. Someone may come into a marriage with a house, and if they keep that house in their name, it's their separate property. But what if they pay a mortgage down during the marriage? Or they make significant home improvements and take on a HELOC? Does that now become a marital asset because our income is paying that mortgage down, paying that HELOC down, paying for all the improvements? It can be a nightmare in a divorce. So a prenuptial can look ahead to those issues, define all these potential outcomes in the beginning, and talk about what's going to happen if there's a separation or divorce. It can define separate property broader than what the law says. It can say separate property isn't just what I came into the marriage with in my bank account, but it's whatever's in my bank account at the end of the marriage. The definition of marital and separate property is up for negotiation and redefinition by the parties in a prenuptial agreement. Terms of spousal support can be discussed. If the marriage doesn't last, is either one of us going to pay spousal support? If this issue is not addressed in the agreement, then the parties default to New York state law. And New York State, as many people know, now has a mathematical formula, a calculation for spousal support. How much does one spouse earn? How much does the other spouse earn? There's several different calculations that go into effect, if there are children, if there aren't children. And then the end resulting number is what the court is supposed to presume one party pays the other. And the duration of that support, how long does it get paid for, is also determined by statute. Depends on the length of the marriage. So a couple can come into a prenuptial agreement and either say, well, we don't know the future, we're just going to leave spousal support to the future. Whatever happens in the future, wherever we are financially, whatever the law is, that's what we'll do. Other people come in and say, we know for sure neither one of us is ever going to want to pay spousal support to the other. We're going to waive those rights right now. Even though we don't know 5, 10, 20 years from now, what I'll be earning, what you'll be earning, what our financial picture will be, we know we don't ever want to deal with that issue. And they completely waive it. And then there are people that do things in the middle. And they say, well, if we're married for at least 5 years, then the right to support will develop, will come into fruition. But if the marriage doesn't make it 5 years, we're both going to walk out. without support, or 3 years or 10 years, or a gradation. If we're married for 5 years, then spousal support will be X. If we're married for 10 years, then it will be 2 times X. And they actually create their own formula. And this is all brainstorming that can be done with the client and the attorney, going back and forth and discussing the pros and cons and the scenarios. If the couple is young and expects to have a family, and one of them is going to put a career on the back burner to stay home and raise children, that's a scenario very different from, it's my second marriage, I'm in my mid-50s, I'm going to be retiring in 5 or 10 years, and I'm okay, I already have assets and I have a pension, and I'm not so worried about support. So it is not cookie cutter. There is a world of creativity that can be engaged in with a prenuptial agreement, as long as it stays within the confines of what the law allows. And what the law doesn't allow, we'll get to shortly. Rights of inheritance. A prenuptial can redefine the rights of inheritance. So under New York state law, if a couple is married, then they have automatic rights of inheritance from each other as of the date of marriage. So that means that whatever the marital estate is, or whatever the assets of one party is, there is an automatic right to inheritance, even if there's no will. And as to what the estate consists of, that's a whole discussion for an estate attorney, but some assets can be named directly to a beneficiary, like a life insurance or a bank account. But if the asset is marital and there's no named beneficiary, it goes into the marital pot, and one spouse will inherit from the other. And that's usually fine. You're happily married, you want that. That's not an issue. Once a party legally separates or divorces, divorce automatically severs those inheritance rights because there's no marital relationship anymore. Most separation agreements, in my 36 plus years, I've only seen one couple in a separation agreement retain inheritance rights from each other. It's a very unique situation, but 99.9% of them, once you sign a separation agreement, you agree to give up your inheritance rights. So the question is, if we know that a separation agreement or a divorce will sever those inheritance rights, why do we want to address them in a prenuptial? Because a couple can be together very happily married, one can predecease the other, but they have a prior family, as we mentioned before, children from a prior relationship. And they want to make sure that certain assets they have go directly to that other family. I have clients who are supporting parents in other countries and want to make sure that inheritance monies will go to their parents if there is a divorce or separation. So we can actually redefine the inheritance statute and what's going to happen, redefine how those laws apply in the prenuptial agreement. And the prenuptial agreement can distribute debt, even if it's debt incurred during the marriage. If you run up credit card debt, that's your responsibility. If I run up credit card debt, it's mine. Or all the credit card debt, it doesn't matter whose name it's in, is marital. Or it's all marital, but you pay 80%, I only pay 20%, maybe because you earn so much more than me. So distribution of debt can also be defined in a marital agreement. So what can't a prenuptial agreement do? It cannot set terms of custody. Even if the couple already has a child at the time they marry, it cannot say, if we ever divorce or separate, you get Sam, or you get Sam and I get Amy. It cannot do that. And that is because when it comes to children, the courts always have an oversight over any arrangement. Now, that doesn't mean that if the party separates or divorce, they can't agree what to do with the children. You're just not allowed to do it in a prenuptial, either with pre-existing children prior to the marriage or children born during the marriage. If there are children prior to the marriage, certainly family court orders can address that. But certainly children born during a marriage, you cannot determine custody of unborn children. And even if you do put it in there, it would not be enforceable. And even if a couple has children together before the marriage, the issues of custody are always reviewable by a court, even if you put it in prenuptial. So I refer, some things are written in sand and some in cement. Sand, the water and tide can wash away. Cement, they can't. Issues concerning children are written in sand. Issues concerning finances is cement. You cannot waive child support obligations either of existing children or children yet to be born during the marriage. Those two things go hand in hand. And again, because the support is for the child, technically not for either parent, for the child. You cannot sunset the marriage. And I was listening to a podcast recently where they were talking about this. It's an idea I thought of many years ago. Not that I seriously took it, but apparently people are now seriously considering it. And that is that a license expires after a period of time. My license to practice law is in existence, but I have to re-up it with the state of New York every 2 years and pay a fee. And if I don't, then I'd be practicing technically, against the laws of the state of New York. Well, some people think that marriage certificates, marriage licenses should sunset. After 10 years, if we still want to be married, then we have to do it all over again. Well, that does not exist, and I doubt it ever will, but we've seen a lot of changes in the last 10, 20 years. But you cannot put that in the agreement. You cannot say that the marriage will end after our 15th anniversary, 5th anniversary. While you can put the waiver of spousal support in the prenup, as I just discussed, you can waive it or you can redefine it. This I kind of put in the gray area. There's no absolute guarantee that will still be valid at the time of a separation or divorce. And it's only because there's this gray area that if one of the spouses ends up bankrupt on public assistance, on disability, and the state is supporting that person with disability payments, Section 8 rent payments, public assistance, the counties that funnel that money can technically step in the shoes of the indigent spouse and seek spousal support, regardless of what the agreement says. And that exists whether it's a prenuptial or a separation agreement. That's just the law, because if there is a responsible spouse, the courts don't want the public coming in supporting someone who's indigent. So I just want to put that out there. And anything illegal, you can't agree to anything illegal. We agree that if either of us is terminally ill, we'll slip each other some medication and do euthanasia or something like that. You can't agree to anything against the law, illegal. And if you or your attorneys accidentally do put something in there, it just won't be enforceable. Okay, what must be included in the agreement? It is very, very important that each party provide a full list of assets and their estimated value. Now, obviously, investment accounts fluctuate. What's in your bank account as you pay bills fluctuates. That's understandable. But a general idea of what the assets are at the time of marriage. I have a Audi vehicle. Kelley Blue Book says it's worth about $23,000. Obviously, that's just an estimate. That's okay. I have a Bank of America account. It's got about $2,000 in it. I have a 401k. It's got about $280,000 in it, which changes in any given day. But a statement of what the asset is, where it is, and an estimate of value. If there's a business, you may not have an estimate of value on a business, but there should be clarity. What is the business and what is the person's interest? I'm a 50% shareholder, or the business is completely mine, or I have 5% of the family business. That needs to all be disclosed. Failure to disclose could cause the agreement to be subject to be challenged. It sounds a bit odd because you think, well, if it's premarital stuff anyway, what does it matter? But disclosure in these agreements is extremely important to the courts. They want to know that the parties were transparent with each other about what they have. Now, if you forget to list a credit card that you owe $1,000 on, or you forget to list a bank account that your mother has you on that you forgot about, that has, $5,000 in it, that may not be such a big whoop. But certainly be sure that you and your attorney go through the assets and the values. And there would be a schedule attached, usually to the end of the agreement, that says, spouse A, these are their assets and values. Spouse B, these are their assets and values. Similarly, debts should be listed with approximate obligations. I have a car loan on the Audi. I have a mortgage on the house. I have a loan against my 401k. And the reason those debts, particularly debts that are secured by an asset, like a car loan, like a mortgage, need to be disclosed, because I'm going to circle back to what I said before. If I come into the house with into the marriage with a house, and during the marriage, that house has a $150,000 mortgage, and during the marriage, we pay $100,000 down on that mortgage. If we haven't been clear that the house remains mine, and we haven't been clear that there is a mortgage on it, and despite that, the house will remain mine, my spouse could make a claim potentially and say, look, I helped pay down $100,000 on her mortgage. The house is hers, she gets to keep it. I'm out $50,000 that I shelled out during the marriage, and I want some credit back. So be sure that these debts are clearly defined and that they're connected to the asset, and how that affects going forward. Is the house still going to be fully separate property, even if the mortgage is paid down during the marriage? Same thing with vehicles. I can come into the marriage with a vehicle I bought just yesterday with a $40,000 loan on it. If during the marriage that loan is paid down, is that vehicle still 100% mine? Investment loans against investments and values of investments, retirements, business interest, all of that needs to be included. Okay. I know we'll take questions at the end. So I'm going to spend a little bit of extra time talking about the role of counsel, because this is extremely important. Each party does not have to have an attorney, but we strongly recommend it. Clearly, these agreements should not be drawn up without the help of experienced counsel. I do want to park on that for a moment because I have seen a lot of prenuptial agreements pop up during divorces where they were not properly done, and they did become subject to challenge in court, and some of them did get overturned. Why is it so important to have a counsel that knows prenups? First, there are attorneys out there who do wills and estate works, and they will draw up these agreements. I don't recommend that. I'm not to say that some of them don't do a fine job, but they don't know the divorce law. You want somebody who knows what happens when people divorce, who knows the matrimonial laws inside and out and has experienced them, to be the one to create this document. We have autopsied marriages, thousands and thousands of them. We've seen what goes wrong. We've seen what falls apart. We've seen the fallout of agreements and asset division. We can't anticipate everything, but we know a lot about where things go wrong. And when you know where things go wrong, you know how to anticipate, get in front of them, and try to draft them in a way where they go right. If you do have a proposed agreement done by your estate attorney, I just strongly, strongly recommend you at least consult with an attorney who knows marital law and prenups. And they may look at it and say it's wonderful, or they may look at it and say, hey, you know what, you need to add this, this, and this. But make sure you get that looked at, kind of like a second opinion. If you are hiring someone to draft an agreement, I would strongly suggest that the fiance have somebody look it over at the very least. Many times one attorney will draft the agreement, the other side will bring it to a lawyer who will negotiate some edits to it. And that's perfectly fine, legitimate. Or sometimes an attorney will just look at it, advise your fiance as to the pros and cons of it, but your fiance doesn't want any changes, that's perfectly fine. And there are people that sign them without counsel. Certainly the preference is that they have counsel Again, not having one does not invalidate the agreement. But if it's a heavy-handed agreement, and these can be very heavy-handed, I make all the money, whatever I bring into the marriage is mine, and you walk out with nothing. That could be enforceable. But if it's so heavy-handed and there hasn't been counsel on the other side, you just begin to create that crack for some judge to step in and say, I'm not comfortable with this. And we all know that regardless of what the law says, it's what the judge says in the end that matters. So many of my clients will pay for the fiance to, if the fiance doesn't have funds, to have an attorney look it over and come up with some edits or changes or questions and have that addressed. The bottom line is, if the prenuptial agreement doesn't get signed, the couple can still get married. It's not holding up the marriage. It's really a question of how badly does one of the other parties want this prenup. I do have a client right now that they've been negotiating a prenup for, I think it's been like 2 years. They're both older. They're not in a hurry to get married. They do want to get married, but things have interrupted their life and negotiations have gotten in the way. And they may never sign a prenup, and they may get married without one, or they may never get married. And that's okay, because they're each free agents to say, how badly do we want this marriage versus how badly do we want this protection? But clearly one attorney cannot represent both parties. And let me just put that as a general rule in any contract, regardless of whether it's matrimonial or not. One attorney should not negotiate for both parties and represent them both. The Court of Appeals standard for challenging marital agreements, whether they're prenuptials, whether they're separation agreements, is still Christian versus Christian. That is New York State Court of Appeals, the highest court of the state. And that case goes back decades, and it is still good law. And there's a lot of law that has come out afterwards, but it is a very hard standard to set agreements aside. The first thing a party has to show, just to give you a general idea, is that there was some fraud, duress, mental incompetence in entering the agreement. So if I sign this agreement and then 5 years of marriage falls apart, I'm going to have, and I want to challenge the agreement because I don't like it, I'm going to have to prove fraud. My spouse committed fraud. Well, how might I do that? Well, my spouse misrepresented the extent of their assets and debts when we got married. Because remember that schedule of assets and debts they're each going to attach? All it says is house, car, bank account. And I have seen agreements, that's all they say. And really, he had a lot more, or maybe he had a boatload more debt that I didn't know about. Maybe he had gone bankrupt and had bad credit, and I wasn't aware of that, and that somehow affected our financials. So some fraud, but it's got to be significant fraud, not just, he never told me that 20 years ago he had a kid out of marriage, in another life or something. It's got to be something that fundamentally goes to making the agreement improper. Duress, that's the old gun to the head thing. Certainly most people don't sign agreements like that, but that's just an exaggerated statement for the standard. There was some real duress. Now, to say, if I don't sign it, he won't marry me. If I don't sign it, she won't marry me. That's not duress, because you can just not get married. That's not something the court considers duress. Trying to think of some extreme examples, like I had a child before the marriage. The child was only 3 years old at the time we married. And the child had some significant disabilities and really needed good medical insurance and a lot of medical care. And my fiance said, sign this, and I promise I will always provide medical insurance for the child, and I will always pay the child's medical bills, and we'll get her the best treatment ever. And that, I think, borders on a duress. This is a child. This is a health issue. This is something that might compel somebody to trust a promise. If anybody has issues like that, tell the lawyer. Do you know what? That can go in the prenup, that there's a prenuptial agreement, that even though this isn't your child, you will continue to carry the medical insurance, you will continue to carry the bills. That can be put in an agreement. So if there are any issues that you think, or any promises that are being made that are really fundamental, make sure they're in the agreement. Mental incompetence, this has come up in marital agreements that some get successfully set aside, some do not. I did have a very dear client, and she literally had a psychotic break at the time that she signed an agreement that her husband put in front of her. Now, her husband was a lawyer. She did not have a lawyer. She had mental health issues. She was going through a very, very difficult mental health crisis at the time she signed the agreement, and her doctor and her psychiatrist were willing to come forward and say, yes, at that very point in time, those few days within which she signed the agreement, or was given the agreement, she signed it, she was heavily medicated, was hospitalized with blah, blah, blah. So it would have to have some real proof behind it, not just I was stressed, I was going through a tough time, I started a new job. It's going to have to be something significant. The flip side of that coin, though, that sometimes prevents people from bringing that defense or that basis to set aside an agreement is if there is a custody dispute and you want custodial rights to your child. Is your mental health condition in a strong enough position right now where you're not saying, yeah, no, I'm mentally, I have mental health issues, but they don't interfere with my being a parent. And they may not, but they might, especially if you have to show something extreme. So something you have to think about or talk to your attorney about. It is very hard to set these aside. However, if one were to challenge a prenuptial agreement and try to set it aside, and if the court found there was fraud or duress or some mental incompetence of the party that signed it, that doesn't mean the agreement would automatically be set aside. The court has to find, the final point here is that the agreement is fundamentally unfair. If I prove that I was under duress when I signed this agreement, but the court looks the agreement over and says, in the context of marital law, of the equitable distribution law and the support laws, this is not a fundamentally unfair agreement. You get half the marital assets, you still have a right to support. They can refuse to set the agreement aside. So it's sort of a two-step analysis, but very hard to do. I have defended these people trying to set these agreements aside, and I've also defended supporting these agreements. And I believe I managed to get one set aside, and I managed to defeat one getting set aside. So, there's, an attorney can come out on either end of it, a party can come out on either end of it. But point being, if you're going to sign one of these, presume that it will be in effect and effective. Don't listen to your friend in the cafeteria who said, the judge tossed mine out. Don't count on that. Okay, what else is needed to make the terms effective? If one of the terms of the agreement is going to involve waiving rights to any retirement accounts, whether they be IRAs, 401ks, pensions, tax savings plans, any kind of retirement account, then we need what is called an addendum. So, for example, if at the time I'm marrying, I've been working for the state of New York and I have 10 years in a pension plan and I've been putting money in a deferred comp and I've got $85,000 in a deferred comp. And my prenup says that after we marry, even though I'm going to keep working for the state and accruing interest in the pension and putting money in the deferred comp account, we agree that will always be mine, not just what I came into the marriage with, but anything I ever put in that account, my spouse will never have an interest in. If we're going to do that, either party is going to do that, or both. After the marriage, they need to sign what is called an addendum. It is a one-page statement that says we reaffirm the waiver of our rights to each other's retirement accounts. Why is that necessary? Because under the federal ERISA statute, which governs retirement accounts and tax deferring these accounts, under the federal statute, those rights can only be waived by spouses. At the time you sign the prenup, you are not spouses. You're not married yet. So many of the prenups, if there will be a retirement waiver, will say within 30 days of the marriage, the parties will execute an addendum confirming their waiver of retirement rights to each other's retirement. And that is usually prepared at the same time the prenup is prepared, but it cannot be signed until after the marriage occurs. So it can be signed the next day. I like to say it's signed within 30 days so people don't forget to do it. And I've had clients forget to do it and they've signed it 5 months later, and that's okay. But it should be signed by both parties. Otherwise, the retirement waiver could be found null and void. And now the 401k that I wanted to leave to my children from my first marriage, I can't. I now have to give half of it to my spouse in a separation or a divorce. So that is very important, the timing of signing it. Generally, what we do is once a prenup gets signed, and let me state, it can be signed 10 minutes before the wedding occurs, whether it's signing, whether you're getting married at the Justice of the Peace in a courthouse, or it's a big, wedding with 20 bridesmaids. You can sign it right before the wedding. I don't recommend that. That's just another one of those things that the court looks for if someone wants to challenge it later. It was handed to me 10 minutes before the wedding. Oh yeah, I saw it previously, but I assumed it was the same one I read a week ago, and it wasn't. There were changes in it and I didn't know it. And I was, getting my gown buttoned up and I signed it because my makeup wasn't finished. Don't have these signed in a rush like that. Make sure that if there are numerous drafts, they are compared and gone through together. There have been claims of people challenging these agreements, alleging that, yes, I signed it a day before the wedding or the day of the wedding, but it's not the one I was shown before. It's not beyond people to do things that are a little bit hinky like that, or for changes to have been made and one party really thinking the other party did see it and agree to it because, they're in a hurry, a lot's going on, it's a busy time. I did have someone sign it, on the golf course an hour before he got married. Fortunately, it held up. That's not a problem, but I just don't recommend it. Try to, if you're going to get these done, see an attorney months in advance. You need to talk in depth about what your goals are, different ways to achieve those goals. You're going to need to think about some of the ideas the lawyer gives you. Process, what do I really want to do? With support, do I want to waive it? Have I considered that I may give up my career to have children? You want time to really process this document. The hope is you never use it. Truly, that is the hope. But should you need to use it, you want it to be worth all the effort you put into it. You don't want to go through doing this agreement and then find that you have 90 other issues to deal with because it wasn't done right when you get divorced. Execution requirements. This is extremely important. There is a Court of Appeals decision, Matisoff versus Dobie, and it related to the execution of a marital agreement. It is clear under New York State statute that whether it's a separation agreement or a prenuptial agreement, it must be duly verified and notarized in the same way that a deed is signed and notarized. This is important because if the wrong notary, some lawyer just doesn't put the proper or full notary and verification on the document, or I think it was more than 10 years ago, I think 15 years ago, the New York State form of notary changed and some lawyer wasn't updated on the new notary and picked up an old one and put it on the document. And the proper precise notary is not used, the agreement's no good. Doesn't matter if everything else was done properly. I have clients that sign these documents out of state. I just had a client, we had to send documents to New Mexico. So we had to make sure that if they're being signed out of state, we have an out of state notary on it. You can't put a New York State notary on a document being signed outside of New York State. So be clear if someone's traveling or you'll be signing somewhere else with your lawyer about where that's being done. If you don't tell your lawyer doesn't know. So have that discussion. the proper execution for not just the agreement, but the addendum also. I remembered what I was going to mention. What we typically do is once the prenup is signed, there's no formality in terms of the parties have to sit down at a table together and there's some magical language. You can just, one can pop into a bank, grab a notary, the other one can go to UPS office and sign it. Your cousin could be a notary. It doesn't have to be done with any formality together, no magic language or anything. And the parties can sign on different days. That's perfectly fine. Same thing with the addendum. But once they're signed, an original of each should be kept by each of you. That's the spouses should each keep an original. And an original should be returned to the attorney of the agreement and the addendum both, because in every county in New York, every county that I'm familiar with, there may be one other, New York County is the only county that does not take recording of prenuptial agreements. Just about every other county I've worked with, we can file an original of the prenuptial and the addendum together. It's a $5 filing fee with the county clerk, where one or both of the parties is living. And it's that way similar to recording a deed. If you ever lose your copy, there is one on file. Think of being married 25 years and then the marriage falls apart and you need to use this agreement. Will you be able to find it? If you find it, will it be an original? Courts want originals, not copies. I have literally, I don't want to tell you how many times I think I've moved about 8 times in my 37-year marriage. I can't find original documents anymore. So just make sure that those get recorded. And if you're in New York County that doesn't record them, then make sure your attorney keeps an original. You keep an original, maybe in a safe deposit box or someplace safe. If signing will take place outside of the country, and I have had some clients sign agreements out of the country, we prefer that they go to a notary, an embassy, U.S. embassy in the country to get it notarized. There are things called apostilles that can be placed on documents out of the country for notaries. But do let your attorney know that so they can check into the proper procedure for you to sign outside of the country. Okay, and then I think I've left us about 15 minutes for questions. And Brittany, if you have any, you can just read them to me. Or anyone that has questions, you can raise your hand and type them in, and Brittany will take them for you.
So the first question is, how does a prenuptial interact with the last testament or healthcare proxy of a POA?
Okay, so this is asking about, I think, a last will and testament, a healthcare proxy, and a power of attorney, which are 3 different things. As indicated before, the prenup can specifically define what the parties want to do with their inheritance rights, even though that's a different section of law. I've done agreements where the parties say, everything we define as a separate property asset will the party can give to whomever they want. If I come into the marriage with a house, and I can say in the agreement that if I die, the house will go to my children from a prior marriage. Maybe in the prenup, I'll say that if I die, even if the house is only in my name and the agreement says it's separate property, I give my spouse the right to inherit the house. Sometimes we say, if that turns out to be the marital residence, my dying, I don't want my kids kicking my spouse out of the house and saying, sell it. Maybe I say that I give my spouse the right to live in the house for their lifetime, and then my kids inherit it. I've seen agreements say my spouse has 2 years or a year to live in the house. And at that point, my spouse can either find another place to live or can buy my children out of the house. So at least my children get the money for the house, if not the house. So again, this can all be discussed with your attorney and worked out in the prenup. As for healthcare proxies, you're free to name anybody on any healthcare proxy at any time. I don't, and this is a question for an estate attorney, but I would imagine because healthcare proxies can be so easily changed, and you can name someone healthcare proxy for one medical situation, but not another, that even if you were to say in the document, my spouse is my healthcare proxy, I'm not sure you can't override that with a new one. I would check that with the estate attorney. As a power of attorney, those are also like healthcare proxies. You can make them and revoke them, make them and revoke them. So unless there's some reason to say you are forever my power of attorney in the prenup, those can be changed. But also understand that if I want to make my spouse my healthcare proxy or my power of attorney, and I say that in the prenup, you still have to execute the proper documentation to create a healthcare proxy and to create a power of attorney. Just saying it in the prenup will not suffice. You have to execute the actual legal documents to do that. I just thought of something. You can, pets have become a big topic in divorces and separation lately. And it used to be that pets could go by who was titled to the pet. If it was a pedigree, an animal that had a certificate of ownership or something. New York State has recently come out with some new statutes and case law governing the ownership of pets. So I would just be cautious on that. If the party comes into the marriage with a pet, and pets have, we call ourselves pet parents now, because pets are very dear to us. And we're getting married, and Rex, we say, Rex, if we ever do get separated, Rex is my dog. You can put that in the prenup, but I'm just not 100% sure that that wouldn't possibly be subject to some review, because some of the new case law talks about, is it a companion animal? Is it a security animal? Is it medically or psychologically, prescribed for me? So it's just an interesting thing to throw out. You can certainly put ownership of pets in these agreements. I just want to say it could be a little bit subject to interpretation, the way that the laws and the courts are starting to go. Okay, thank you, everyone.